that nothing much during so argued that local police officials were not informed before initiating the search in the morning of 2026. Sri Sibbal submit that the respondent number 2 had no case of incident in the capacity of the Chief Minister, C being of Trinamool Congress, gone there, information that certain unauthorized persons entered into the premises of Mr. Prateek Jain, who has been entrusted with party's election work. According to Mr. Sibbal, nothing available in the iPad except some election-related documents with which ED has no concern, and they should not have entered the premises. People would also submit that to of the TMC West, its national party, by is also a jet protecting. This is your argument. Submit. With the jet protecting, it was the duty of the director to accompany her entered of Sri Shyam Diwan appearing for so and so would argue when the matter that correct that some untoward when the High Court proceeded to 9th January on 14th January, the matter proceeded peacefully but at the request of the ED. Therefore, this court should wait for the outcome of the process for the High Court. Having heard learned counsel for both the parties, we are of the view that present petition has raised a serious issue relating to the scope of the investigation by the ED or other central agencies and interference state agencies. According to us, or of law in the country, and to allow to function independently, it is necessary to examine the issue so that the offenders are not to be protected by protected of law enforcing agencies of a particular post. According to us, larger questions are involved has been raised and are involved, which, comma, if allowed undecided, comma, further worsen this. There will be a situation of prevailing in one or the other state, considering that different outfits are at different places. Full stop. True, it any central agency has to interfere with the election work of any party, comma, but at the same time, if the central agencies are acting bona fidely to investigate any serious offense, comma, the question arises as to in the field of activity, comma, can in carrying out their investigating power in a post of para. ISO notice. Let counter affidavit be filed. Can you file it within 3 days?
Not possible.
Within a week.
If sometimes it's 2 weeks. Maybe minimum 2 weeks.
2 weeks. Then we if it takes the digital
Not
evidence.
deserving, Maharaj. No issue on that.
Yes, in 2 weeks.
2 weeks.
Post on days 15. Post the matter on 3rd February.
Lord, prayer
Full stop. In the that it is directed that shall preserve the cease and other stores containing of both the premises on 8/1/26 as described and the CCTV camera devices containing of nearby areas. Now what it is to this investigation and this is 8/1/26 full stop. That the further the investigation FIR number 4 of 26 registered at
one more 7 also, my lord. I have placed on
it is there in the main petition, but
additional document. It was filed
7 of
subsequent.
26 registered at Tronic PS, Nagar.
No, there are 2 from Shakespeare's.
Name the police station properly.
It's in E. E has, my lord, the page 126 E from Shakespeare's Sarni, and 2 are from elect. The index, my lord, in
just IA
yes, it's a document compilation.
has also direct that FIR and FIR number 4 of 26 police station Shakespeare Rani and FIR number 5 of 26 and 7 of 26 registered at electronics shall remain in state till the next date of hearing.
Or any other FIR pertaining to
Aware also.
this is
We
not
do not
like
know. Be clarity in our order.
Yes,
You
sir.
can't say this.
No, I understand.
This is not proper.
Grateful.
Whereas I have one request only, just whereas normally investigation will be taken is an alternative.
No. You see, in view of section 6, if they were armed, they were acting in good faith.
I'm only saying, well, investigation without
And the delicacy of
but equally well,
if you proceed with the investigation in any manner,
without
then it will be
any
difficult.
coercive steps. Without any coercive steps.
No, my lord, that will not.
Secondly, well, if your lordship is granting a stay on investigation, you have more time to reply, well, because then there will be a complete takeout.
No. 15 days is
more.
on.
Well, maybe 3.
Have been passed after 10 minutes of hearing. That we are inclined to, but since parties have raised that much, it is necessary for us to record also.
Yes,
Because
be a little
everything.
now
And
that
then
it is,
everybody will say that so much was argued.
now that little more time can be given. That's
Yes, next case.
My lord, the IA for addition of party, but chief secretary and others are being joined. And my lord, prayer suspension. No, suspension power is with. That's my prayer. That's my prayer.
We file a counter.
That's my prayer.
strongly opposing this kind of
Notice may be issued.
Let counter to IA
But yes,
may also be filed.
yes.
It's not even listed.
Even my lord, copy is
Because
given to
it's
them.
got-
I have tendered it.
These are the strange procedure. Whatever
Let
it
them
is.
file a reply. I mean,
Just not.
You only file counter, not saying anything. No passing
Yes.
no order.
We'll file
Passing no orders on that.
counters in applications, then the main matter,
there are only two. No, only one matter and application.
To IA number so and so. Which are those IAs?
We'll give the number.
It's not
We
numbered.
file before the next date of hearing.
Yes.
Yes, next.
28.
Right.
22 connected. 20 is connected.
Huh?
20 is connected.
Yes.
It says something must.
Yes, next.
This matter, this is for anticipatory bail. Now he has no criminal activity.
You impersonated this.
That is the basis of statement which is made between.
You have said in
Yes,
that settlement agreement
that's right. My lords, we can.
members of other person
That's
which
right. 60. So the money has now been given.
is
Paid 60.
On the ground of settlement.
Mr. Counsel for the petitioner who submits that the petitioner was not needed, and as a matter of fact, which is that page? No, 60 something different. Is that agreement?
Page 44. Sorry, I'm so. Agreement is at page 44.
Okay. In council petitioner would submit that petitioner was named FIR and as a matter of fact.
The complainant, accused persons have already compromised question has been refunded to issue notice returnable on 10th February. In the meanwhile, petitioner so and so, police station so and so, offences under section so.
Very quick. What should pass over? Item 1.
Wait, please look.
Or at the time of issuance of notice, not your lordship had directed me, then granted specific liberty. I'm
Sharma, this is an offence of 1992.
That's correct, my lord. I understand that.
1992 means 36 years.
Facts
He
is
sought to
different,
be
your lordship.
arrested. Needs to be examined. Listener, considering that the committed on 29/8/92, more than about 30, and presently the petitioner is in jail in 8/25 after his surrender. We are inclined to suspend the sentence and release the petitioner on bail.
Lordship may say in the facts, he has not undergone even 1/4 of the sentence.
Therefore, considering the facts and circumstances of the case, we are inclined to release the petitioner on bail. It is directed that on petition petitioner shall be released on such terms and conditions as may be imposed by the trial court.
deeply aware.
Records have been summoned. Let record of the trial court be summoned, posted, no matter be listed on
Very deeply aware.
yes,
Pass over item 5.
Please, the lordship.
password.
Yes, this is that matter where the
Only about cost.
The notice was issued to the limited aspect.
Yes, yes. Tempted.
Yes, sir.
Under the impugn order, the High Court has quashed the notice. Additional District Magistrate Hapur, so and so ये अपने order में लिखा हुआ है. 28. There are two matters.
yes, no, exactly the same order has been passed.
ये देखिए बनता है ये कैसे
जी
SLP का जिक्र है.
जी
ये कॉमन ऑर्डर है करके दोनों का एक अच्छा दोनों का कॉमन ऑर्डर ही बनाओ. So and so in case number 6, while quashing the notice before the High Court, a cost of has been imposed on the state of UP in each of further reserving liberty in favor of the state from the concerned additional district magistrate. Having examined, find that the High Court has recorded finding that the concerned district magistrate has passed the under challenge before the High Court in modified exercise of power or due to any in such view of the matter, imposition of cost of rupees 20,000 and directing the same and liberty in favor of the state from the additional district magistrate justified. Accordingly, we set part of the impugn order imposing cost of rupees 20 on the state.
What's the question of law and that would be also present?
I have already dismissed that part. That part is already covered. Notice.
Very well.
Yes.
Deeply aware.
Am I audible? Hello, am I audible?
Yes.
Hello, this is a transfer petition by a wife. It's in Kanpur, and of the Section 13A petition from Gwalior, which is approximately more than 300 kilometers far. Now, also see Annexure 4 of my petition, Malos. There was a difference in 21 involving the similar parties, which was also transferred to Kanpur from Gwalior. Annexure 4, Malos. Malos, page 38, Annexure P4.
Yes.
This is the
Our order. Then let it go to the same place.
In this matter.
Yes.
Prior to the mediation, we were informed that they are willing to settle the matter into mediation, and they would be willing to settle with the amount that we stated, right? The settlement should be arrived at an amount of 10 lakh rupees.
Malas,
Now,
for 10 lakhs, they initially offered 18 lakhs.
The child is in all.
Just 1 minute.
That amount, they went to 30 lakhs. Now they also have the custody of the child. I am paying, why the order dated in order dated.
This is only a transfer petition.
Transfer petition, Malas.
Harass us in the mediation.
Malas, that a man
they kept
who
on
is so
saying that
self-centered, he's hardly bothered. He's not ready to pay anything. We all for his son, he refused.
Since 2020.
He's not willing to pay a single penny for his child.
Considering that, okay, then has allowed petitioners TP 2840 of 22 and HMA number 540A of 2020 for Gwalior to Kanpur city, comma, the present transfer petition dissolves so that the pending duties are tried family court can't. Accordingly, the present transfer petition is allowed. It's tough. Yes.
Much.
Yes.
Transfer petition filed by the mother-in-law, brother-in-law.
Mother-in-law. Deviate.
We all are the petitioners here. Brother-in-law, mother-in-law, age 80 years, a sister-in-law, and a relative 1 years.
It is from Visakhapatnam to Mumbai.
More importantly, that the
why deviate? By the wife should be transferred to a place where deciding.
No, but Lordship, my problem is number 56. We are by the lawyer there. Learned ACJM.
Court wants you to appear. And others may be exempted.
That's all.
So far that is concerned. This transfer petition appears to be not filed on a premise. They appear to be not aggrieved. They've been asked to appear personally. But if that is the grievance, they have a remedy to file Because there is no other ground stated in the transfer petition for seeking transfer. But now with my 4-year-old daughter, Manoj, it is not possible for me to travel.
We can
The trial is already going on there. They are appearing there. They are appearing in this one also through their lawyers.
On hearing parties, we are not inclined to allow the transfer petition seeking transfer. The under the domestic violence elicited by the respondent wife. However, direct that that is fourth additional chief judicial magistrate Andhra Pradesh shall not physical appearance of the
Let's consider saying the other respondents, the husband will be exempted, subject to what my lord speaks.
relative unless their physical appearance is mandatory particular date of hearing.
they can join through VC lordship.
That's
They
what
can
my
join-
lords have said.
The relatives of the husband shall appear through video conferencing on such dates appearance has not been directed by the court.
Grateful, Manoj. Absolutely.
Yes.
21.
Yes,
Caveator is present here. It was passed to.
caveat,
Caveator is present
eviction.
from a shop. Please, Your Honor.
On market.
417
eviction, 18th March 2017, and you are resisting.
Lord.
Then who
There's
is
a-
resisting?
I just filed a revision.
Hmm.
That's all. In Control Act, there is no
Means resisting in a legal way,
that way.
not
Not
physically.
not
Yes, yes.
not under the Delhi Rent Control Act. There is no appeal.
Time, how much time?
No, Your Honor, just
An oral agreement.
no. Lord, I've got the
And he
material.
honoring it last so many years.
The material is
The person with whom he has oral agreement.
just Lordship, just allow me about 2. I won't take a Lordship more below that. Lordship, I'll just statement where I said so that all these facts agreed to sell this property to a person through so and so. They admit it. They admit that they were dealing with this man. Stands and they said this was only to in order to change the nature of the property from freehold, from leasehold. This is their stand.
See,
When the document comes, not mere just comes, it says permission to sell. I just point that P2. Lordship may just have P2. May have P2, and then I'll also. It is permission.
Page.
That page 8. Page 68. You may see the title of this. Permission to shop number 30A, Khan Market. Eventually, when he comes in,
2010.
yes, madam. But of the rent petition.
And
This
you
is
are a
the-
tenant since?
Since 1970.
Then it will happen. How landlord will say,
No, Lord. It's not out of frustration. Give it to me. That was the market rate. Market forces have changed.
it happens.
It's a different 2.5 through court.
Always happen. After 15,
I'm
20
paying.
years.
So here they want to sell it. Then come to refer to.
You see, this particular area, at least
Yes.
in the Asia, I do not know where some
Yes.
this Khan market.
It at one time it was, seems to have lost its sheen. Now.
It has not lost its.
It's only a place where everybody goes for their.
I do not know whether it is eating.
It's more like that now.
But it is
market
very
is
popular.
famous for that.
It is very
Therefore, he wanted to sell it. Therefore, my lord, the idea was to sell. And now, unfortunately, under this act, my lord, this is a strange act. It doesn't appeal. There's no provision for
to issue notice in Mr. Siddharth Dave
that is good enough, my lord.
for the landlord, leaving all his bail matters and bail matters.
That's why I had to take a pass over. I'm very sorry, man.
And my lord, a caveator got a pass over. That's good enough reason. Waiting. Lordship,
Same time, 6 months.
Statutorily, there are 6 months. The court says, I will not even grant you that. Please leave it.
2017, you were allowed 6 months. Several 6 months have
Lord,
gone
after
past.
that, I had a right to file a revision. There was a stay order in that revision. And then I've been paying money the market rate.
Now we can allow further 6 months. Further 6 months from today.
Lord, could your lordship just consider increasing that amount? Why? Because it's a shoe shop.
Amount of,
I have to
amount
of the time.
No.
I have to sell this entire. I have to sell this entire material. I'm not shifting to another place. Down the business.
He owns it.
But I will not.
Next to?
Next, the shop which is let out for 8 lakhs, and I am 2.5 lakhs. He has to shut down his business.
Not.
This is not.
To take on
At
the
least
business.
my learned friends should be fair.
Upon hearing learned counsel for the petitioner and learned counsel for the not inclined to entertain this SLP. Accordingly, the SLP is dismissed. Considering that the subject premises is a non-residential, we allow the petitioner the same for a period of 6 months from post out. Accordingly, he is dismissed and the petitioner directed to hand over vacant position subject premises on or before on or before today is 15th before 16th of July 2026.
You can pay.
Petitioner usual undertaking before the registry of this court also continue to pay the monthly rent.
It was fixed as user charges, my lord.
User charges
High Court one.
as assessed by the High Court. Next.
I'm grateful.
You can lordship consider 2 months more, Lord.
What you will do in 2 months? You
We
will,
will. This is all shoes which I bought from people.
yes,
I have to
next.
sell them.
Matters completed.
This is completed. Regular matter, we are not taking up.
One small request in 101.
Yes.
Just a small. Lords had directed us to file one of the deposition which was not filed by us, but there has been some we have not been able to file. Carrying up, my lord, may kindly give me fresh direction so that I file that physically.
Both of them are so happy when he said.
Sure.
Two.
Okay.
Lords had a marathon, lords.
Yes.
So, my lord, need fresh directions from my lords to file that, my lords, because my lord.
What fresh direction? When there is a one direction,
No, lords, there was some technical glitch carrying a printout. So it says that the
101.
yes,
You for the petitioner.
yes, appellant.
101 is allowed 4 weeks time.
2 weeks, lords. We are ready with that.
To file official documents
And written.
and submissions. After 2 weeks.
Deeply obliged.
102. It's a very, very short matter. It retains position a lot.
For the respondent in this matter,
102 is a very short matter. in the coming week.
And yes, it will be taken up, it will automatically be repeated.
A small request in 103. This week it could come in the week on 28th or 29 January. Grateful, man.
Thank you. अरे किसी को बुलाया